judge bench. The second point, and Ananya is also with us on the broadcast. Ananya, come in on this point as well. Can the right to wear hijab be claimed as freedom of expression? Is this covered under Article 19? One of the arguments that the petitioners had raised was, we are covered by the Puttaswamy judgment. This is our freedom of expression. Allow us to do that. And that's one of the key questions that has been framed. Talking about the order or the judgment rendered by Justice Hemant Gupta, take us through the key portions of the rationale which has come out. Ananya.
Well, definitely, the proportion here remains to be seen in that though Justice Hemant Gupta has actually dismissed these appeals, while Justice Dhulia has actually gone into, in fact, allowing these appeals. A beautiful judgment has been written out, in fact, by Justice Dhulia, and I'd like to take you through these pointers.
Okay.
So, these pointers actually, the very important point that is there is, under the constitutional scheme, wearing of hijab should simply be a matter of choice. It may or may not be a matter of essential religious practice, but it still is a matter of conscious belief and expression. If she wants to wear a hijab, even inside her class, she cannot be stopped. If it is worn as a matter of her choice, as it may be the only way a conservative family still will permit her to go to school. And in those cases, her hijab is the ticket to education. The unfortunate fallout of hijab restrictions would be that, in fact, the girls would miss out on their education. So beautifully, Justice Dhulia has actually taken up a problem that had persisted in fact, in India, and specifically in the Muslim side, where girls are not allowed to wear the hijab when girls are asked to wear a hijab whenever they go outside, and if they don't do so, they are not allowed to go out. So this has been addressed by Justice Dhulia, and that is why this opinion, this in fact judgment has come in from his end, allowing these appeals to waive off the hijab ban. And now, very interestingly, the matter now goes before a larger bench, which would be either a 3 or 5 judges bench that the matter would go to. And it would be very, very crucial, Anusha, to see as to who would be these judges and whether the matter would come up before Justice Lalit's retirement or post that. Anusha.
I'm going to go to the part that Ananya was referring to. Justice Dhulia has written a very interesting judgment, as Ananya rightly pointed out. If viewers, you go to page number 71, and these judgments are available to you on the Supreme Court website. Any citizen of the country can download this judgment and read it. Justice Dhulia goes on to say, paragraph 81, that the unfortunate fallout of the hijab restriction would be that we would have denied education to a girl child for whom it is still not easy to reach her school gate. This case here, therefore, also has to be seen in the perspective of the challenges already faced by a girl child reaching her school. The question court would put before itself is also whether we are making the life of a girl child any better by denying her education because she is a hijabi. That's the word. Those are the words that the judge is using. Paragraph 83, which I believe is very, very important, Ananya. By asking girls to take off their hijab before they enter the school gates, it's a first invasion on their privacy. It's an attack on their dignity, and then ultimately it's a denial to them of secular education. These are clearly violative of 19(1)(a), Article 21 and Article 25. This is clearly a line which Justice Dhulia has taken according to the 9-judge bench order of the Supreme Court, the Puttaswamy judgment. Ananya.
Well, definitely. It's a very, very framed judgment that has been given out by Justice Dhulia. And remember that case Puttaswamy still remains the classic case law when it comes to right to privacy. And it is not only with respect to the right to privacy that it's referred to, it also is referred in some cases. And clearly pointing out that the right to privacy is also invaded if we are taking off the hijab choice from a particular girl. But the point that he's actually highlighted very well is that the challenge is that the girl child, specifically in the rural areas, face when they have to go to school. Because remember that still conservative thinking and conservative minds are there. And in fact, this is what Justice Dhulia has actually beautifully given out, clearly saying that the unfortunate fallout of the hijab restrictions would be that it was denied a girl child of education. In fact, it is kind of a ticket for the girls to go to school. So if that is, in fact, the ban is given on that, then that would be problematic. From this perspective is what Justice Dhulia has pointed it out. However, Justice Hemant Gupta, on the other hand, has dismissed all of these appeals and upheld the Karnataka High Court order clearly.
Okay. Me and Ananya were talking about what Justice Dhulia has said, and we read out the operative portions of the order. I'll go back to Ananya, and Ananya will discuss what Hemant Gupta has said in his order after talking about Justice Dhulia. Before